Welcome to the Connect podcast. This is the weekly podcast of the California MBA featuring one-on-one interviews with movers and shakers in the mortgage industry. I'm Susan Milazzo, CEO of the California MBA, and I'm very happy that you could join us. Before we get to today's guest, I'd like to thank our 2023 President's Council sponsors for their incredible support in this year. Those companies are AmeriHome, ArchMI, Consolidated Analytics, Funding Shield, Rocket Mortgage, and Western Alliance Bank. Thank you all for your continued support. Of course, that helps strengthen our organization so that we can continue to be a strong voice in the California State Legislature on all issues related to the mortgage industry. So grateful for your support this year. And with that, I want to turn it to today's guest. I'm very happy to welcome my friend Robert Finlay with Wright, Finlay Zak to connect. Robert, welcome.
Thank you very much, Susan. Excited to do this. Thank you for inviting me.
Yeah, we've known each other for a long time, so it's very nice to finally have you on Connect. And I do always like to kind of get started with some background on our guests. So give us an idea how you got into legal representation in financial services.
Yeah, it's it's hard to believe it's been 29th year I'm about to start, so it's been quite a while. So I didn't intend to get into the mortgage industry, but I did. I came out of law school in 1993, and I wanted to get into some sort of real estate, but unfortunately there was no real estate going on at that point in time because California's economy wasn't that great. So I took the first job I could find in Orange County, which where I'm from, and which was doing post-foreclosure evictions. Very glamorous and exciting stuff that I wanted to get out of about as quickly as I got into it. But as I started, I was getting great litigation experience. I was doing trials, I was doing all sorts of motions and going to court 4, 5, 6 times a week, which was fabulous experience compared to a lot of my counterparts. So I did that, but it ran its course. And after about a year and a half or so, I moved over into litigation group of the firm I was with at the time and started doing mortgage-related litigation, defending lenders in loan origination and loan servicing issues. Continued doing that, kind of expanding my litigation experience until it was 2002 that we started Wright, Finlay Zak. So we just celebrated our 20th year last year, and actually 2 weeks ago today was our 21st anniversary. So we've been around. My partner Robin Wright and I have worked together for 29 years, and Wright, Finlay Zak, we primarily represent financial institutions in mortgage-related litigation, compliance matters, licensing, and regulatory matters.
Great. Well, we've been grateful to work with you and your partners, and congratulations on the milestone of making it 21 years. That's pretty incredible.
A lot longer than I ever thought, but it seems to be going
never
well.
Know when you get started, right? You and several of your attorneys at the firm have been active with our legislative committee and our legal affairs, legal agenda for many years, and we're very grateful for the expertise that you all bring. There are definitely issues that we've addressed over the years that your particular background in the industry has been really helpful for us to kind of formulate our paths forward. So always appreciate you being a part of our legislative committee. But what do you see as the most important legislative issues that we'll be facing in 2023?
It's a good question. I mean, with the economy, teetering, is it going to go into recession? Is it going to be a bad recession or a small recession? Nobody knows. But I think we definitely will probably see an uptick in foreclosures, I think, in 2023. And as a result, or I should say, even if we don't see an uptick, I think that the legislature will anticipate one. And so I think we'll see foreclosure reform. We saw several bills last year that wanted to significantly extend the foreclosure process. Last year they wanted to create a 2 different paths for foreclosure, when there's equity in a property and when there's not equity. So I think we'll see more of that. And I think even some of those same bills will come back. The legislature seems intent on making sure that people who have equity in the property are given additional opportunities to avoid foreclosure. So I definitely think we'll see that. And all of that sounds, it sounds good on paper, and if done properly, I don't think is a negative. But a lot of times the laws the way these laws are proposed are not very they're not very practical, and they end up causing a lot more harm than good, and create a lot more procedures in areas where potential litigation could arise for many of the CMBA members. So I think we'll see that. I also think we will see a continued effort to prevent investors from picking up properties either at foreclosure sales or otherwise. That was a big issue last year and the year before. Sacramento seems to think that all the properties are being purchased by investors, which are turning single-family neighborhoods into rental neighborhoods, and they want to put a stop to that. How they're going to do it is the key, because I think it can probably be done effectively. But so far, most of the laws that have been proposed usually end up harming lots of other groups. So, for instance, last year there was one where they wanted to add a capital gains tax for anyone who flips a piece of property, but as drafted, it would have affected you or I, Susan. It would have affected any of us if we were to sell our properties. So luckily that one was shot down because it was so poorly written, but I think we're going to see more efforts in that area as well.
Yeah, definitely another busy year for us. We will see the change to the foreclosure process for sure, and we're going to be starting our legislative committee calls here in the next few weeks. So we'll get underway when that we have language on that bill. But again, thank you for all of the support that you and your firm have given us on our legislative committee. But Wright Finlay has also been involved with us for many years on legal cases, and in particular crafting amicus briefs in important cases that you have often brought to our attention. And so I was hoping that today you could share with our listeners some of the issues surrounding the most recent case, and I'm going to butcher the name of it, Honchariw and versus FJM. I always see it written, I never have to verbalize it, so I probably did not say that name correctly, but I'd love to have you talk about the issues around that case.
Yeah, and I've heard it pronounced several different ways. I'm not sure the right way, but Honchariw is the last one that I've heard that I think seems to stick. So we'll go with that. Yeah, well, first off, I think the CMBA does a great job with amicus efforts on key issues that impact the industry, and it's actually one of my most favorite things that I do is because it's great because we pull together a lot of times a lot of different groups that we all put our money together to come up and challenge an issue together. And Honchariw was one of those. And Honchariw involved default interest, and whether you can charge default interest on a loan following a payment default. So the typical situation goes, borrower defaults on the loan. Let's say their interest rate is 8%, and then once they default, though, there's a default interest rate provision that allows the lender to bump the interest rate, let's say, to 10%, which was the situation in the Honchariw case. And it's been done like that for decades, if not longer. The standard has always been that the default interest, the ultimate charge, must bear a reasonable relationship to the potential loss that the lender may suffer as a result of the default. And that's always been the case. And so in the Honchariw decision, when you start reading the opinion, that's where the court's headed, and also identifies that it was the borrower's burden to prove that there was no reasonable relationship. But then the Court of Appeals just jumped to a conclusion that anytime you charge default interest on the entire unpaid principal balance following a payment default, that is per se illegal and violates the applicable law. And so that kind of sent shockwaves through the industry because it changed what lenders have been doing for a long period of time. We filed an amicus brief with several other groups trying to request that the California Supreme Court would take a look at this issue and weigh in on it. Unfortunately, at the end of the day, the California Supreme Court said, no, we don't need to look at this. It just didn't catch their attention to something that they felt they needed to weigh in on. So it's a final decision at this point. There's a lot of nuances to it. There's a lot of things that lenders and servicers can do but they have to be careful about doing it. One thing I want to highlight from it, the decision does not impact necessarily the ability to charge default interest on a matured loan. It's a different issue. So what we've been suggesting to everybody is when it comes to charging default interest, talk to your attorney, reach out to our office or whoever you use, and ask first, can I charge default interest? And if so, how best to do it to protect myself from getting sued And the other thing we're suggesting to everybody is have an attorney take a look at your loan docs, because they can be beefed up to increase your chances of successfully charging default interest. So unfortunately, that it was a good experience in the fact that we pulled a lot of groups together to oppose the decision and try to get Supreme Court review. Unfortunately, we were not successful. But if I could add, we did have a win. The CMBA was involved this last year, which was the Sheen case, which involved the Homeowner Bill of Rights. And again, that was an amicus that we wrote on your behalf, along with several other industry groups, and that was a big win. This California Supreme Court came down and held that there is no cause of action for negligent review of a loan modification, and I think that's really important for the servicers out there, because they've been, for 10 years now, they've been getting sued for what I call negligent loan mod review, and the courts have been split on whether that was a valid cause of action. With CMBA's help, we were able to, the Supreme Court was able to come down conclusively that that is not a valid claim. And so I think that's going to save a lot of our clients and a lot of CMBA members money over they'll avoid litigation going forward. Also, it'll save them money in litigating the cases that borrowers file. So I think that was a big win.
Right. No, that definitely was a big win. And, again, we are grateful for the expertise that you bring to our activities from a legal standpoint as well. We do like to, when we're able to weigh in on cases that are, huge, great impact to the mortgage industry here in California. So thank you for helping us with that part of our advocacy efforts. As you know, California MBA has a very active diversity, equity, and inclusion committee. But I also see that your firm is involved with several national associations promoting diversity. How has involvement in those issues benefited the firm?
Yeah, so the Wright, Finlay Zak is and has been for about 5 or 6 years certified business-owned firm. It's certified by the WBENC. And we're also a member of NANWOLF, which is a national association focused on women-owned law firms, minority-owned law firms. It's been great. I mean, we're still trying to, navigate our way through it, but so far it's been great, and it's been nice that we were able to get involved. I think before it became something, more, before a lot of other groups and firms started to pay attention to diversity. But I think the two things I've kind of noticed from it the most is first is community. There's definitely a sense of community out there where women-owned and minority-owned firms and people are really out there to try to help each other. So they're looking out, mentorship opportunities to help others advance along in the industry, but then also the companies, the businesses looking to support each other within that community. So I think sense of community has been the biggest thing that we've noticed. The second is opportunity. A lot of opportunities, both internally and externally. Opportunities to go out and speak at industry events, both on diversity issues as well as just, I think industry wants to have diverse speakers, and so our firm being women-owned, as well as having several minority and women partners and speakers, and so they're able to. There's opportunities to go out and speak in the industry. There's also opportunities internally. I think, Robin Wright is our managing partner. She's, and is obviously a woman. And so she's been running our firm for quite a while. I think there's a lot of opportunity within our firm for women to move up in the partnership ranks and ultimately into leadership roles, both internally and externally.
That's fantastic. And good for you and the firm. I have to talk with you in another context about having you on our DE&I committee to share some of the information that you benefited from this involvement with these associations with other people in our membership. So thank you for sharing that. So on to a topic that's outside of the mortgage industry, one I know we both share a passion for, which is wine. I happen to know you are a big fan of the Palo Robles wine country. I believe that's where you are recording today's podcast. So can you give our listeners an idea of what's your favorite winery if they happen to find themselves lucky enough to be in the Paso area?
Yeah, we love Paso, and it's a place we've been going for years and years and years. And then 2011, we were lucky enough to buy a second home up here that we use. We rent out on Airbnb and VRBO and come up as much as we can. So we love it. The whole area up here, a lot of the wineries it's much more homey or just friendly. You go in, you meet the owner of the property. Sometimes you meet the winemaker, which is really nice. But as far as favorite wineries, that's tough. I'd probably say that I have two right now that are favorite. One is Alexander, and that is wonderful winery. It's just small. You go in, one of the most intimate tasting experiences that you could go to. You go in and you're not in their house, you're on their property, and it feels very intimate. And the wines are absolutely amazing. And the other one that we've been enjoying quite a bit lately is Austin Hope, which is something that I think most people are familiar with their cab. I think you can get at Costco, but they have a lot of other really, really good wines, Syrahs, blends, and we just love the atmosphere there. And we're lucky enough actually last weekend to go to both. So good timing with the question. And but there's so many good wineries. So, and I know you and I have shared several bottles, and then hopefully I'll bring some more for you to try something different next time.
It's it is a really unique wine country area. If anybody has a chance to go there, I'd highly recommend it. And I agree with you. The wineries, you have so much more of it's more of an intimate setting. Like they want to talk with you about their, how they develop these wines and history of the land that they grew the grapes on and things. It's a great experience.
Yes.
So, you and the firm have been members of the California MBA for years, and as we've shared on this podcast, you're very active with us, for which I'm very grateful. Can you talk with us about why you're such a big supporter of the California MBA?
Well, because you're a leader, of course. That would be the answer.
I did kind of set you up for that. No.
No, I think the CMBA does great things, and I think it's a leader in our industry, and we're happy to be a part of it. But I would say that the things I think the most value I get out of it, and I think the most value that the CMBA gives to its members is education and advocacy. I think the education sessions that we have at the various conferences are fabulous. I think there's a lot of people that don't know everything that's going on in the industry, or maybe they know their little piece and they can go to some of these conferences or participate in some of the webinars, and they're going to learn so much, and it really allows them to stay up on top of the industry, as well as some of the industry articles and updates that the CMBA sends out. But the other one is advocacy, and we talked about two of those things, but the advocacy that is done in Sacramento is just huge. Without the CMBA's activity there, I think a lot of bills would be passed, and a lot that shouldn't be passed, and a lot of bills would be passed in a form that they shouldn't be passed. And so I think we're, as a community and as an organization, we're able to protect a lot of our my clients and your members from Sacramento and the things that they might otherwise do.
Right.
But then the advocacy on the other end is also the amicus that's done. There's laws there's opinions that come out that need to be corrected or need to be overturned, and I think we're out at the forefront of trying to do that, and always looking out to protect the members' interests and make it as easy as possible for them to make money and do what they do.
Yeah, thank you. Yeah, advocacy definitely the cornerstone of our association. And again, thank you so much for the support that you and the partners at Wright, Finlay Zak have provided us over the years. Greatly appreciate it.
Thank you very much. Look forward to doing it for many more years.
And thanks for joining us today. And thanks to all of you for joining us and listening in on the Connect podcast. To access any of our past episodes, you can follow us on our YouTube channel. We're also available on SoundCloud, Apple Podcast, and Spotify. That's it for this week, and we'll see you next time on Connect.